Everybody. Thanks for joining us. We're going to get through a few interesting issues today and give you an update on what is happening around the JobKeeper aspect and a few other tax issues that Mariana and commercial issues that she's dealing with, which is pragmatic. And then also the bigger issues that are probably coming through at the moment is human resources and what's going to happen with JobKeeper and all the changes that are coming through now through the economy as the government tries to continue this good fortune we have out the other side and build on top of the bounce that we've seen. So we'll get going as quickly as we can, and we'll get across to Mariana to talk about the end of JobKeeper and what people should be considering about and some other opportunities that are out there to be able to provide cash into businesses.
Thanks, Todd. Thank you for that. And as you know, at the end of March, JobKeeper comes to an end as we know it. That means the last payment will come in April for our staff. We know that, and we can see from some businesses that JobKeeper has been propping them up, keeping them sort of safe, if you like. And what businesses are we talking about? And you know, as you probably aware, a little bit of that hospitality, anything to do with overseas, where your business is overseas, entertainment, you know, events, all those kind of areas. So there has been talk about more people putting forward to extend it for certain professions. But really, you know, what can you do? I think, well, run for the hills. No, I'm just joking. I'm just trying to wake you up a little bit for the morning, get you ready for Nick. But no, I think seriously, I don't know there's an extension coming. We haven't heard anything. We haven't seen anything. If it comes, it'll come in the last minute. And it probably wouldn't be narrow who it applies to. The vaccine is coming out, as you know. Things are sort of going back to normality a little bit. Maybe not for some, but what I see in the city coming in on transport, there's a lot more sort of consumer confidence, if you like. And that may mean, and there's events being booked, like face-to-face events as well. So things are sort of progressing, if you like. So what can you do? Okay, we don't have JobKeeper, and JobKeeper gave us cash. So what can we do to get some cash? So obviously we know there's the government guaranteed loans, but you know, you've got to go through the rigorama. We have our debt advisory that can help you with that. So please reach out if you need that. But if you can't, or you've already gone down that track, there's this great thing that's come out in the 2021 budget, the carryback of losses. So what that's saying is, big picture is you've got 2019, you would have maybe had a profit, potentially even 2020, because, you know, COVID sort of hit that last 4 months. But it could be that you're in a loss 2020, you're in a loss 2021, etc. What it's us saying that you can carry back the losses. So when you do your 2020 return, if you do have a loss, you can basically use the tax effect of that loss against your tax that you paid in 2019. If you had no tax payable in 19, this does not help you. But let's say you did well and you do have tax payable in 2020, and in 2021 you made a loss. Again, you can carry that back. So you've got the 2020. So when I say 2020, I mean 30th of June 2020, 30th of June 2021, and 30th of June 2022 to potentially carry back a loss. You can only use, obviously, the profit that you may have had in the prior periods, starting for 30th of June 2019 to be consumed. So that's a great thing, because what that means is that you can get back money. So if you pay tax of 100,000 in 2019, and in 2020 you made losses of, I don't know, 100,000, times that by, you know, your rate of 26%, you can carry that back and get that cash back, the liability back. So any tax that would have been paid equivalent to the loss you made, tax affected, you can get back that cash.
So Mariana, that's moved from being an accrual that you can use to pay against future to actually to get cash back now. So they're cashing it out.
That's right. You know, it's a bit like the R&D incentive. You know, you sort of get the money back. So I think that's great. What are the disadvantages? One is you have to have all your tax returns. You have to have 5 billion turnover. Well, that's worldwide. Yeah, that's probably good for most of us, so that's okay. So that doesn't limit us. I think what does limit us is a bit is the timing.
So it's less than 5 billion, Mass.
5 billion
Yes.
turnover.
Yeah,
Yeah,
yeah.
so
So
global.
it's only like you're talking your majors before
Yeah,
you.
that probably doesn't apply to, but most of the clients listening today would it apply to. The only thing about it is the 2020 period, obviously the tax office isn't ready. So they're saying you would actually do it in your 2021 return. So it'll take a bit of time. So we're coming into 30th of June 2021. So effectively you'd be wanting to do your return in July, August, much quicker, unless you've got an audit situation. But even in an audit, I think you can sometimes do your return based on your management accounts and then amend if you have to amend. But if you're desperate, there are ways around it, I guess. So just something to talk with your advisor about. But that's a good one. Now, the next one is the instant write-off. Now, most of you be thinking, so what, I haven't got the money anyway to do it. But say you are in an industry where, you want to, you're coming out of COVID and you need to buy some plant and equipment, some stuff that you think, okay. Now, remember, since 6th of October, the budget night, you can spend any amount if you're under the aggregated turnover of 5 billion, any amount, and claim it straight outright. That's pretty good, right? And you can do that up to 30th of June 2022. What does that mean? That means that now, if I was going into a profit or a slight profit, I could buy a piece of equipment that I need for my business, not because I'm getting a tax deduction for it, that is going to progress my business, put myself into a loss situation in 2020 or 2021. I can push that loss back to 2019 when I made a profit, assuming you made a profit, or 2020, depending what year you made the profit, and I can get my money back. So that's really, really good incentives there. So I think those two things is worth talking to your advisors about when you're doing your 2020 return or sooner, when you're planning. Now, the other thing is the corporate tax rate is going down from 26%. So it's 26%, 30th of June 2021, going down to 25%. Remember, this is a long-term goal to get the tax rate down to 25%. And it's very equivalent to the capital gains 50% discount. So if I sold an asset, I'd pay 24 cents in the dollar. If I pay a dividend, now I've got 25 cents in the dollar, right? So very equivalent to selling an asset versus paying a dividend. But just keeping in mind that 30th of June, I've paid tax at 26%. So you might want to pay yourself a dividend. I mean, look, that's 1%, right? But just think that, when you pay a dividend in the following year, you can only use franking credits up to 25%. So that's why you might want to pay yourself a dividend at the end of this year. And if it's a large dividend, it can make up a difference. So that's something else to consider. Now, we've seen some audit activity. What audit activity? I've seen some JobKeeper reviews on some of the not-for-profits. They've given our calculations to them. We've been cleared. Excellent. Well, the client's been cleared as well. And that's all been great. But just to be aware that the ATO isn't going to, now everybody's coming out of it all. I know all businesses haven't come out of it, but according to the ATO, they're ramping up their activity. So make sure you have your documentation. If you do something, make sure you can support it with JobKeeper. Another thing we've seen is, they're hitting the high net worth individuals. That's nothing unusual. The private area, private owned and wealthy groups. Now, you know who you are. And basically they call it the top 500 private groups. Now they're usually a lot bigger, those top 500. Yeah, so what they're targeting now is the next 5,000. And they're not as big. So I've got it written down here, but the next 5,000, you'd be looking at the 50 million group turnover, which doesn't take long to get to there. But they're also going to the medium and emerging private groups. And that can be anywhere between 5 million and 10 million. So they do have a target and a focus. So it's worth going into the ATO if you're interested and having a look at privately owned and wealthy groups, and just see if you're in that category or you think you might fit in that category, what are they looking for? And again, your advisor can expand on that if you like. So I was thinking about this presentation and I was thinking, well, what do you want to hear about? And I've only got a few minutes, but it just prompts you to think, well, depending on your industry, and look, we have very wide industries and not all going to fit into this category, so you can tune out for a minute. But if you do fit into the category, it might be worth looking into a little bit more, where you can get some money back. So travel agents, and interpreting services and so on, then there's a once-off grant. Now that closes on the 13th of March, which is only a couple of days away. But if you don't know about it, go in there and have a look right now. Show Starter Loan Scheme closes on the 16th of June. This is more from a performing arts perspective, live shows. So there's money there, but that's more of a loan. And the loan can be up to, what do they say here? You know, up to 5 million, but it's 50% of the budget, whatever the production budget is. So that might be an opportunity there, and a 5-year repayment on the loan. Another one I've seen, which is a big one, the government is spending $1.5 billion on the modern manufacturing strategy. And what it is, it's looking at, they've got all these roadmaps, very exciting stuff. And it's money they're going to give you to develop in certain areas. So what areas are we talking about? Or you might be linked to these areas. So food and beverage, medical products, recycling and cleaning energy, defence and space, resources technology, and critical minerals processing, easy to say. So there's some things to think about. What does it mean? It's very merit-based. You have to put an application in, but you could get 50% of your expenditure back. And it's $1.5 billion, so there's quite a bit out there to grab. So if you're not aware of it, I'm sure if you're in those industries, you would be aware of it, but if you're not, have a look. It's on the website. Just pop in modern manufacturing. Now, I have mentioned this before. JobMaker is still out there. Look, the JobMaker, it's not easy to get. It is for new staff. It starts sort of from September as your baseline, and it goes till October 2022, I think it is. Yeah, 2021, not 22. And the particulars about it, it has to be someone you hire from the age of 16 to 35, not replace, but hire. So you're increasing your headcount. And what are you getting? You're getting, if they're 16 to 29, you're $200 a week. And if you're 30 to 35, you're getting 100. But there's more criteria on that. It means that also when you hire them, they would have had to been on JobSeeker or some sort of allowance. Not so easy to get. But keep it in mind, if you are hiring a lot of people, if you're in those universities hiring people, or, you know, hospitality, you're hiring new people there in that age group. Another one we saw there was Jobs Plus New South Wales scheme. Again, that is started in 15 December 2020, and it goes to 30th June 2022. You need to be creating, you need to have about 20 full-time staff already, so already cuts out a few people, and you need to create about 30 new full-time jobs up till the time of 30th of June 2024, but you would have had to have the contracts in before 30th of June 2022. So there's a bit of criteria around it. But it again gives you an opportunity. They slash off what's the benefit. It's slashing off some payroll tax, gives you some money to do training. So there's some rebates and discounts available there. So again, worthwhile having a look at. It's not going to be for everyone, but you know, if you need money, these are some of the things to look for. That's all I had there, and happy to answer questions towards the end.
As I just had a couple of things, the new partnership guidelines came out last week, which we're obviously going through now, about how partnerships are treated.
Yep.
And that's probably going to be an evolving issue. And do you get the feeling that the ATO is working through those sort of things that they've had on their books for a while, that they're now trying to get some clarity on and bring those out?
Yeah, I mean, that's been coming for a long time. So I think, you know, it is a useful guideline. We're going through it at the moment just to see what it means. So any partnerships that are out there, to be aware that that ruling is out.
Yeah, and we're seeing in what we're doing that the ATO is focused on recovering all of the pre-COVID debt. Is that what you guys are sort of seeing as at the moment, or are they still relatively passive?
No, I think they're starting to ramp. They're very generous previously. I'm not saying they're still not generous, but it's going to be harder to say, you know, I'm not going to pay my debt when it comes due. Obviously, they've always had extension of time or payment plans in place, so that's always available. And it'll always depend a bit on what industry and what story you can tell.
And that's also lodgements as well. You got to make sure all those lodgements are done.
Yeah, no, that's very important. Just because of COVID, they say, you know, it's not enough that you can't lodge and pay. So you have to lodge and put a payment plan in place. That's what they're stating right now. So gone are the days where, okay, well, I just didn't lodge and you're probably all right with it all, or I didn't pay and we could get a deferral. We always get a deferral anyway. We just don't go around putting our heads in the sand because we know that there is a problem. And if you're upfront with them, they've always been very good. Still the same, I think. So I don't think anything really changes.
And their data has improved obviously as well, because now they're getting the superannuation data as well as the tax data.
Yeah, look, they're always evolving.
Yeah.
They've got the manpower. I mean, well, they've got the dollar, and what they do is they link a lot of things like motor registry. This is how they get motor vehicle information to know whether you're paying FBT or not in your company. There's a lot of things they can link to, and hence why, you know, little red lights go on. I'd love to be in the ATO and find out what they actually do, but I'm not. You know, I'm sure there's this little computer going, oh, look, look at this
you
one.
might find it exciting, Maz. A few of us might find it disappointing, but okay.
Yeah, well, I mean, if I was on the other end of the audit, I wouldn't find it very exciting. But I mean, it's just interesting, I should say, how it works. Because if you understand how it works, then you can advise more and you can say, well, watch out for this, that kind of thing. But there is something in that privately owned and wealthy groups in there. There is a little, you know, if you go to the ATO website, and happy to share it with people here, what attracts our attention. And they actually indicate in there, you know, non-lodgement, business structure, transactions and tax crime. Obviously, tax crime is a bit of an obvious one, but non-lodgement, you know, it attracts their attention. And then you got to look at what industry groups you're in, because that even construction is one of the big ones they look at if you're not playing ball. I'm not sure why. Do they think that that's the more dodgy field? You know, people don't put their tax returns in, they don't lodge. I mean, obviously our clients do. The ones that I do know, obviously they wouldn't probably be our clients if they're not lodging returns.
But we've seen it, Mariana, with our clients who have been selling major assets, probably pre-CGT assets, and there's been an article in the paper, and the ATO has picked it up from there and then wants to see all the documentation that goes with it.
Yeah, that's right. And I mean, I guess we don't have a concern because we're acting in good faith and we're doing all the work behind it and we have support for it. And so we don't have an issue. But that's right. I think that if you're a well-reputable organisation and they know about you and it slips into the paper, they're going to have a look. Someone's going to tap on your door and say, well, but where's your documentation to say you've sold all that, and did you get the right market values?
How does it work? Yeah, how does it work? How have you got pre-CGT and how have you cost-based it and all of those things? And they'll be proactive about that. And the good thing, though, from the purchaser or from the seller sort of view is that what I've seen is they effectively sign off on it. So when you lodge your tax returns, there's no issues.
Yeah, I think if you're a company and you have assets and they're pre-CGT and they've maintained pre-CGT and you sell them and you liquidate the company, that's when they're going to come and look at it, because obviously the liquidator is going to go and ask for a clearance.
Yep.
And then they're going to come and say, well, show me how you got this. And, you know, sometimes you're selling a lot of assets that are pre-CGT. There's a lot of different values. Have the shareholders change? You know, there's a lot of things that can trigger a post. Yep. So it's very important to get that right.
And that's going to happen a lot more probably this year as there's a bit of consolidation in the market and a bit of M&A.
Yeah. And I'm sure you're going to see a lot of it, Todd.
We'll see. We'll get to that. All right. We've got a few questions coming through on that, so we'll get to that at the end. But we'll switch over to the people issues and Nick giving us his eminent views around what's happening in the market and how this is going to change now over the next 3 to 4 months, as it has changed over the last 15 months, and we'll bring through the impact on whatever businesses can have from there. Righto, Nick, you're up.
Thank you. Eminent's probably a bit of a stretch, but I'll take it. And thank you, Mariana. That was interesting. Bit of a pivot into the employment human resources space. There's so much going on in my world. I feel like every time I pick up the paper, there's an issue that's relevant to sort of employment lawyers, whether it's what's going on in Parliament, you know, this working from home dynamic that is continuing, COVID and all the legislative changes, the vaccine, sport even, you know, contractual and other disputes. There's just so much activity. I had a chat with someone the other day that works at a fairly large law firm, and they said that they had polled a lot of their lawyers about whether or not they wanted to continue with, working from home arrangements, how much they wanted to continue working from home, provide feedback on the reasons for wanting to work from home. And interestingly, she said that not one person in response to that poll mentioned COVID or the pandemic or, safety concerns arising out of COVID as a reason for wanting to maintain working from home arrangements. So, and look, I see that, in my own business that, the world has changed. People are comfortable with working from home arrangements, but I think they're less about the pandemic now and more about just the way in which people want to work and the flexibility that is afforded to them. So it's just an interesting little insight into what we're probably all experiencing. What I'm going to cover is set out on the slide here. There's obviously a lot of detail associated with all of these topics, and I don't intend to address all of it with the level of detail that I could, but just to get a bit of a feel for some of the issues that are likely to be relevant in the next few months as we sort of return to a bit more normality. Starting off with the end of JobKeeper at the end of this month, one of the most significant changes that occurred during JobKeeper were these JobKeeper stand-down provisions, which, quite apart from the payment regime which commenced with JobKeeper, enabled employers to be afforded with quite broad powers to essentially stand down staff, not only on a 100% basis, but partial stand down, so to reduce their hours, provided there was some nexus to the pandemic. Also afforded employers powers to do things like change duties and change location of work. That was, I think, an obvious response to the fairly rigid pre-COVID statutory provisions that live in the Fair Work Act, which hadn't really been accessed before. There's a particular section, 524 of the Act, which suddenly became really relevant to businesses when COVID hit, because it talked about when companies could stand down staff, but it had nothing to do with the pandemic. It wasn't expressed to relate to the pandemic. It had traditionally been applied to things like strikes and inclement weather and things like that. But suddenly it became everyone's most popular section. Because it was very rigid, JobKeeper introduced these more, I was calling them watered down 524 provisions. So employers have been taking advantage of those throughout JobKeeper. JobKeeper 2.0 meant that there have been two categories of eligible employers. There were legacy employers and there were eligible employers, both of which had the ability to issue these stand down directions. And a lot of my clients have been relying upon these directions to keep their business viable. Unfortunately, at the end of this month, those stand down provisions that are currently in place are repealed. They simply drop dead. And despite there being some discussions about extensions or continuations or grandfathering, it just hasn't happened. I'll come to the IR reform as a second topic, and there is some discussion at the moment about some extensions, but that's legislation that is yet to be passed. So what that means is any existing JobKeeper stand down directions will cease, which means that you'll need to start thinking about, if you've got employees that are stood down because of one of these directions, how you're going to manage standing them back up, or if that's not permissible or it's not economically feasible for the business, what other options do you have? So that sort of takes us back to this old, when I say old, it's the prevailing provision which still lives in the legislation, which is this 524. Now, when these stand down provisions end, we'll be back in 524 territory. Now, as I mentioned, it is a lot more difficult to fit into 524 than it was to fit into these watered down JobKeeper stand down provisions. So what you need in order to have the ability to stand down staff under 524, you need to show that the employee cannot usefully be employed, and it has to be because of a stoppage of work, and that is for a cause for which the employer is not responsible. So COVID clearly springs to mind as a cause for which employers are not responsible. But as some of the case law in this space has shown, it is not that easy to fall within that provision. You know, the cases have clearly identified that, you know, mere reductions in work or deteriorations in working or employment conditions, business conditions, don't necessarily cross that threshold. You need a genuine stoppage of work. And that means, in realistic terms, a cessation of trade. So it might be that the business is not trading actively, but there is still some work to be done by employees. And what the cases have shown are that you do need to have really that cessation of trade. And then you're looking at whether or not some employees don't have work to perform. So I think the obvious lessons from this are, unlike the JobKeeper stand down provisions where you could partially stand staff down, you could say to an individual, your 38 hours a week will now become 10 hours a week. When those provisions are repealed, you'll have a choice with respect to individual employees to either keep them on or stand them down completely. A 524 stand down is not a partial stand down. But the other thing that's relevant is, in your employee group, there might be some employees that still have work to perform and others that don't. So you might have a situation where some employees are doing no work, others are doing work. So it's definitely more complex, and the cases, albeit there's not many of them, they do provide guidance on the factors that you would need to take into account before making an informed decision about whether a stand down is lawful. And if you don't get it right, or even if you do get it right or you think you get it right, the way the legislation works is that an employee can commence proceedings in the Fair Work Commission, and you'll have to have a fight about it, which unfortunately usually involves cost and time, and the Commission will ultimately make a determination having regard to sort of fairness between the parties as to whether or not that stand down was lawful. If stand down is not something that you're necessarily comfortable with, or there's ambiguity about it, then there are still other options, but most of those options would be negotiated options. So I would have thought, if you're in a category where you've been relying on JobKeeper, you've had employees stood down under JobKeeper directions, coming up to the end of this month, you'll have to look at some of these other options. And that might involve liaising with your staff. If it means that you can't continue to fully employ all your staff in their current capacity, worst case scenario would be redundancies of staff. And if you're looking to avoid redundancies, then you could always reach agreements. And I emphasize agreement because it would have to be an agreement, and the lawyer will tell you that those agreements should be documented. But agreements with staff about potentially, partial stand downs, or taking leave without pay, or reducing hours, or reducing remuneration, whether that's for discrete periods or ongoing periods. So all of those things are potentially negotiable, but don't simply assume that when JobKeeper finishes, you can issue directions to staff to work less hours, or drop their pay, or alter their duties, because those JobKeeper protections just will not be around. So it will be interesting to see how that plays out. There really has been a period now where these laws have stood behind employers and protected them, and there's probably been less cases going against employers in respect to these directions. So when these protections end, I guess we enter into another sort of higher risk phase as to how these sort of directions and arrangements will play out. So just be cautious and get some advice if you're unsure. So just moving on to...
So Nick, just on that,
yes.
Is the feel that a lot of those casual employees that have been sort of sitting on JobKeeper for a while, that they will sort of probably be let go, or there'll be a rationalisation of that? You'll probably get some of them going back into the unemployment sort of area.
I think that's clearly the lower risk play for employers to look at casuals first. Certainly that would be the advice that I would be giving to employers if they had an alternative and a casual workforce. But look, as I'll come to, the status of casuals is also in a bit of a state of flux at the moment. So despite, calling someone a casual and you thinking that they are a casual, those casuals might have rights also to challenge.
Could be part-time permanent.
Yeah, what they would call a dismissal,
Yep.
or to look at a conversion into permanent.
It's going to be fun for you.
Yeah. So this IR reform, what happened and look, it's been a little bit overshadowed by what's happening in Parliament at the moment. But in December, following a period where the government and the unions and other interested groups got together and they established these working groups, the aim of which was to come up with improvements to the IR system because of the impact of COVID. What happened was in December, the government introduced legislation into Parliament, which has been sort of generically referred to as this omnibus bill. And that was a response to these working groups. Now, it's been controversial on the basis that the unions have said, this is not what we agreed to, and it's a departure from what we've agreed. None of that is surprising, but as far as the passage of that legislation, it's now passed the lower house. It's in the Senate. There is a Senate report that's due at the end of this week, but a number of senators have indicated that they oppose it, and I don't expect that the version that, if it's eventually passed, will be very different to the legislation that was introduced, just given some of the commentary. So I'll just deal briefly with what that addresses. Look, the most significant change is in relation to casual employees. There are two cases, and a lot of this is sort of happening at the same time, but there are two cases that were very controversial a couple of years ago, known as WorkPack. WorkPack was the employer where employees that were paid as casuals and described as casuals and classified as casuals sued their employer, and the court held that they were basically permanent employees and therefore entitled to annual leave and long service leave and sick leave and other permanent entitlements. The other thing that happened was the company tried to say, well, we've been paying these people a casual loading of 25% of their hourly rate or 25% above what we're paying permanents. We should be entitled to set that off, because if you're telling us now that these people are permanents, then we want that back. The courts in both cases said, no, that's wrong. So both of those cases have gone to the High Court, and the High Court hasn't set a hearing date, but I expect it to be in the next couple of months. And a lot of business groups are strongly pushing for the High Court to clarify this issue. And one, tell us, what a casual employee is. And secondly, to tell us about whether or not this casual loading can be set off if a casual employee is ultimately determined to be a permanent. So in response to those cases, this legislation has specifically introduced or proposes to introduce a new definition, a statutory definition, which has always been missing, of what a casual employee is. And interestingly, and I expect this is going to be very controversial and very much opposed by the union groups, what they're proposing to do is describe a casual on the basis of how the offer of employment is framed and if that offer is accepted. So the relevance of that is it almost ignores what actually happens during the employment and focuses just on the way the offer is framed. And they've specified that the offer needs to basically say that there's no firm advance commitment to continuing and indefinite work according to an agreed pattern of work. And if that offer is accepted in circumstances where it's very clear that there's no firm advance commitment and basically it's going to be irregular, sporadic work, then that person is a casual. I'd be highly surprised if that's what we end up with, because it really does enable employers to have well-drafted employment agreements. And once those agreements are accepted, suddenly it crystallises this casual treatment. So it's clearly trying to get around these cases that look at the totality of the relationship and the actual manner in which work is performed. Because in these workpack cases, you had people that were described as casuals, but in reality, they were working what amounted to full-time hours. And the court says, well, really, these people are full-timers. The other thing that this legislation proposes to do is deal with this double dipping point. So they basically try to enshrine in this legislation that if someone's been paid a casual loading and ultimately a court determines that they are a permanent, then the employer can set off that casual loading against the entitlements that the court orders them to pay in relation to things like annual leave. So again, a direct reaction and controversial. It's proposed that these changes be retrospective as well, to apply to casuals that are already employed. So all of that will be hotly debated. The other one is about casual conversion. Now, all of the awards already include a casual conversion clause. And some of you might employ staff and may not be aware, if you're employing casual staff, that you're meant to notify your casual staff that there is these casual conversion rights in the award. It's usually a schedule to the award. So that's always been the case with modern award covered employees. But what the legislation is proposing is to basically extend this to all casual employees, and also to put the onus on the employer to notify eligible casual employees that they can make this conversion from casual to full-time or casual to part-time. There's eligibility criteria. I think it's a 12-month rule. You could have a 12-month period of employment. I think 6 months of that needs to be sort of a regular pattern of work where you're basically working either part-time or full-time hours. Then the company has to notify the staff that they can make that conversion, and it's either accepted or it's rejected. In the same way, the employee can make the request and the company can either accept it or reject it. But if they reject it, it's got to be on, reasonable business grounds. So that's a bit of a game changer. A lot of organisations don't do it at the moment because they just don't know that it exists, and they can get away with that because it's really, the onus is on the employee to make the request. They're trying to flip that. So the onus is on the company to make the request. The other change I foreshadowed when I was talking about JobKeeper stand down directions, they're looking at extending, I guess you could call them some of the JobKeeper flexibilities, but only for specified awards. They've got a list at the moment of about 10 awards. I think the restaurant industry award's in there, hospitality's in there, retail's in there, pharmacy, nursery, commercial sales. So these are the identified model awards that clearly the government has determined cover the industries that were most detrimentally affected by COVID. Those award covered people can be subject to JobKeeper type directions, but only about duties of work. So basically directing someone to perform different duties, or location of work. They don't, in the current version of the legislation, they don't deal with hours of work. So what I talked about at the start, there's no, at the moment, proposal to allow employers to give partial stand down directions to staff. So I think we have to live with this Section 524 full stand down world again, which, as I mentioned, I think will create some disputes. The other, probably most significant change is they're looking at criminalisation of wage theft. So some states already have introduced legislation in the past couple of years, but they're looking at federalising this criminal regime for deliberate, systematic, dishonest wage theft on the part of employers, where they know that they're underpaying and they refuse to modify those practices. So looking at huge potential fines, like we're talking over 5 million, and imprisonment for individuals. So that is a bit of a game changer, and we'll see whether or not that goes through. So just moving on to the vaccine. When talk of the vaccine came into the market, there was a lot of debate amongst employment lawyers as to whether or not the government would give employers the ability to mandate employees having the vaccine. That was months ago, and there's yet to be anything really. So there was a lot of commentary about whether or not employers would have the ability to sort of mandate the vaccine. Not a lot has happened really, other than the vaccine commencing a rollout. The government hasn't really gone near employer powers. The government's come out clearly and said that they are not going to mandate the vaccine. They've stayed away from what employers can do. All that's happened is the Fair Work Ombudsman has released this guide. Despite it being 5 or 6 pages, it doesn't actually say anything of value. It simply says that whether or not an employer can mandate the vaccine for staff will depend on whether it's a lawful and reasonable direction, which is basically the common law position that has always been there. And whether or not something is a lawful and reasonable direction is an ambiguous, difficult question to answer. So it just doesn't really tell us much. My personal view is that it's going to be very difficult for an employer to mandate COVID-19 vaccines for staff, unless you're in an industry where you're dealing with vulnerable individuals like aged care or childcare potentially, or you're really at the coalface of dealing with COVID-19. The fact that Australia has done so well with respect to managing COVID through other means, social distancing, hygiene, cleaning products, et cetera, I just think it's going to be difficult. Now, I've had clients that have asked me to draft or review COVID-19 vaccination policies. Like, there's some of these policies floating around that industry groups are rolling out. The ones that I reviewed, I thought were problematic because they basically suggested that the company could mandate a COVID-19 vaccine. I just don't think that would stand up at the moment, given what I've discussed. Certainly, you could look at implementing a type of policy, as long as there were appropriate exemptions. Like, there are always going to be medical, religious, or other attributes that people will rely upon to not be vaccinated. I just think a black and white policy proposing mandatory vaccination for staff is problematic at the moment. And the fact that the government has stayed away from it, and the Ombudsman has said, tread very carefully. Basically, the first line of the Ombudsman's guidance is the overwhelming majority of employers should assume that they won't be able to require their employees to be vaccinated against coronavirus. So it's a case-by-case issue, but tread carefully. Interestingly, there was a couple of unfair dismissal cases that were about flu vaccinations, and they both came out in the last couple of months. So a lot of employment lawyers were eagerly awaiting to see what the court said about obviously what is a similar issue. And I'll just read an extract from one of them, which is interesting and relevant to COVID. It says, this is from Commissioner Hunt in one of these cases. It says, in my view, each circumstance of the employee's role is important to consider, and the workplace in which they work, in determining whether an employer's decision to make a vaccination an inherent requirement of the role is a lawful and reasonable direction. It's not inconceivable that come November 2021, employers of men engaged to play the role of Santa Claus in shopping centres, having photos taken around young children, may be required by their employer to be vaccinated, at least against influenza, and if a vaccination for COVID is available, that too. So things may change, and really it depends upon the circumstances of the employment. And Santa Claus in a shopping centre is a fairly extreme example. Yeah, look, it was basically a quote from a case where the judge used the example of men in shopping centres playing Santa Claus, perhaps being required to get a COVID-19 vaccine. And that's a very specific example where you can see the clear vulnerability of kids. But don't assume that everyone will have the same broad power to mandatory implement vaccine directions to staff. Just moving on, I'll cover the last two very quickly. So employee contractor, a bit like the casual employment issue in Australia. It's one that just constantly comes up. There's still no statutory definition of contractor, but there was this case in the UK which has got a lot of attention, basically where a group of UK Uber drivers sued Uber and asserted that they were employees and not contractors. What happened was, in the UK, instead of just having an employee and a contractor, they have a third definition which sort of sits in the middle that is called a worker. Now, these Uber drivers were held to be workers, so they sat in the middle. And a worker in the UK is someone that is not incorporated. You know, they're not contractors that are providing their services through companies. They perform work personally. They can't delegate work. They're required to attend work. They're not performing work through a company. I mentioned the employer is not a customer or a client. So very specific to their legislation. But the relevance to Australia is there's been more and more judicial commentary suggesting that we need to update our laws to deal with things like the gig economy. And judges don't have the power to make those laws. Clearly, it's on the legislature. And I think there will be pressure to do that, whether it's immediately or in the short term. There are two High Court cases that are going to be heard together shortly. One was about truck drivers that ran a trucking business that were called contractors forever but were held to be employees. The other one was about a labour hire business where they had a labour hire worker that was appointed to do construction work and was held to be a contractor. Everyone appealed and they're both being heard together. So again, people are waiting patiently for the High Court to say, this is what an employee is, this is what a contractor is, or legislature, please, we need a new definition to deal with this sort of ambiguous gig economy situation. So not really much to report other than a watch this space, but it's the sort of issue that comes across my desk every second day. You know, is this person an employee? Are they a contractor? The answer is usually it's hard to say. And there's a risk that this person, notwithstanding that you've paid them as a contractor forever, might turn around and say that this arrangement is a sham. I won't go into the last topic just to give Todd some time. I'm conscious of the time. It's really just, I've seen a big spike in these general protections claims during COVID, and I expect that to continue. So I might just hand over to you, Todd.
Thanks, Nick. Informative, mate. There's a lot of stuff going on, and I expect it's going to come into our phase, and we'll probably have to deal with a few things together, hopefully, trying to sort them out. I'll get into a pretty short update of just where we are in a commercial and risk sort of issue. So the predicted insolvency wave, it's a myth at the moment. There was a 61% increase in February compared to January, but January I think was a record low. So the boom for insolvency in January hasn't occurred, and at the moment everything is still down 50% on 2019, if not more. So that is just not occurring yet. Whether that leads to a build up over the rest of the year and goes to more like we saw with the GFC, where it rolls out over 2 to 3 years, appears more likely. But this is a unique scenario where we are not seeing things that have happened before. Even the government has come out and said that it didn't predict the bounce back of the economy from a recession as quickly as it occurred, and we don't know what's going to happen in the next phase once JobKeeper ends and all of those things happen. So everybody's just got to stay the course and see what happens. In terms of the new restructuring and reduced liquidation that they introduced at the start of the year for small and medium enterprises, that's been largely ignored. There's been probably less than 10 of the SME restructuring. It is very refined and in a very focused area, and I think everybody is now actually dealing with things commercially rather than going through a formal process. But that may change as issues come forward, and the major push I see in a few of those is actually in landlord disputes, where landlords unwilling or unable to make a determination around a commercial arrangement, sometimes because the large ones just do not have the capacity to do that under their approval structure. So would rather just be pushed into an arrangement rather than having to consent to it. So that's something that may evolve. The ATO, as I said, we're hearing and seeing evidence of them collecting pre-COVID amounts and focusing on those, and then they'll deal with COVID after that. That's the similar approach with the banks, with all of the parties who had issues pre-COVID that have now been nursed through. They're expecting to start making those parties to make some changes or to gradually exit the banks. That may be after March quarter accounts come through. So in April, more than likely the way things are going, I suspect the banks will probably be looking into next financial year once they get June accounts, unless there is funding requirement for wages and things like that, which will mean that the entities are pretty much done. There is a significant risk coming through a lot of the SMEs at the moment, where debtor finance facilities are being utilised. As sales have sort of declined, that means the debtors have declined. So there is a significant cash lockup, which is requiring cash to go in from owners or other parts, and maybe from non-payment of creditors, to be able to keep working capital going. Part of some of the things we've been doing is trying to negotiate some unlock of those positions to keep working capital live, to be able to keep businesses moving forward, even if and while looking for a solution in terms of a longer term. In terms of funding structure, there's heaps of cash available and it's looking for a home. So if there are anybody looking for an acquisition or expansion or something along those lines, there is plenty of people looking to invest in good businesses and help them grow. So there's plenty of that. We're talking to a lot of our hedge fund and private equity guys who are really keen to put some money into all sorts of different things, including property development, which has probably been driven off the back of the solid sort of growth that everybody's seen over the last 5 to 6 weeks, with a view that that's probably not going to change in the blue chip areas. There's 2 steps or a different phase out in different areas, particularly out west for units, which is a little bit more uncertain, but there is interest in looking at good projects to making sure that things work. So all that means in April 2021, there's going to be more uncertainty as things change again. There's going to be more risk built into it, but there's also opportunity to be able to work with people and look at commercial solutions rather than having to go, Nick, close your ears, formally go and get legal advice around things and whatever else. So there is opportunities here for everybody to look at it. What you need to do though is have a sort of a good solid plan, an underpinning plan, and be flexible with that and understand the impact of changes. So if you're going to change this or that, what does that mean? And make sure it's a positive impact or it's minimising a negative impact. In terms of other issues that are hitting the economy, everybody has seen the latest thing with Greensill, which is a interesting business. Tanya? It's obviously fallen over. There's a number of rumours going around about what it's all about in terms of why it has fallen over. It's a very complex business arrangement in terms of the acquisition of payables and then discounting, paying the parties on discount and then packaging up that as a security structure. It's out there and will be very difficult and complex to unwind, particularly when you have the impact of insurers as well, security structures and the underlying assets and businesses. So the obvious issue to look for is Mr. Gupta, who is one of their largest clients, and what impact that has on a lot of his steel businesses across Europe. So the implications here are in 2 or 3 major businesses. Telstra, I understand, was in there as well, but that should unlock. But the vast majority of this business is across Europe. So there is potential impact, and they own a bank in Germany and all of those sort of things. So there's major impact in Europe, and out here we'll see a little bit of blowback, but I think it'll probably unlock a little bit easier here rather than over there. So they're the type of things that we're starting to see driven. We've obviously got a little bit more fraud and other things being exposed as well, and there are a lot of disputes arising around between families in businesses and how to exit and whatever else. And the other issue is chasing expansion, whether that's the right thing to do now, how to do it, and all of those. So that's a lot of the things that we're dealing with. It's not that pure insolvency, it's more of the advisory work, and I can see that continuing along for the rest of the year because This uncertainty is going to create opportunities and an ability for a lot of parties to maximise those opportunities. And then everybody else is just going to be paddling along and trying to keep going. So on that basis, we'll switch over to some questions. And Mark Boffa will run through yours quickly. Mariana, on instant asset write-off, is there really no limit to it? And does it include real estate? I understand it doesn't include real estate. It's more.
Yeah, no, I wish it was that good. No, it's depreciable assets, so plant equipment, etc. What you imagine it to be. No, I probably used a sweeping statement there, so it confused you. But no, you can't go and buy a house. But you can buy a car, write that off. So
I've seen a number of real estate assets that should be written off, but probably not for that reason.
And do you remember cars? You've got your car limits as well. So don't go and think you can buy,
So corporate ute is where you need to get to.
yeah. Don't think you're going to go buy a Rolls Royce and get a tax deduction for that. So it's you've got your thresholds. So again, vehicles you have thresholds, and property no houses. Yep. That's a different section.
And franking credits, does the reduction affect the franking account? So if you've got $1 million in the franking account?
Sadly it does. So you had 30 cents in the dollar if you hadn't. And the idea would have been before they went down to pay some franking, to pay some dividends. So utilize the 30 cents in the dollar. Otherwise, if you don't utilize it and pay a dividend, now it's 26 to 25, so not such a big difference, but you may have slowly been losing them if you haven't been paying dividends. And you may not have paid a dividend because you needed the cash as well. So there may have been different reasons.
And accounting question from the restructuring guy. Where's the other side of that transaction? If you're losing that, does that go where against retained profits, or where does it go?
Yeah, a good question. I'm a tax person, not accounting person, but basically it's lost. So you're not actually, you don't pay it. So it's sitting in your franking account, right? So your tax paid is.
So it sits on the tax side of your accounts, not in your accounting side of your accounts.
Exactly, yeah. It's sort of below the line, if you like. It's the tax liability, and the franking account says you've paid tax of say 500,000, and you can pay a franking credit with franking, franking credit up to 500,000, which you gross it up and etc. and you pay a dividend. But it's going to be less because you have to get the amount and times it by the rate, and it reduces it. So and yes, you do lose some of it.
Another one. Will they, on the tax rate, will they be reducing the rate on passive investment vehicles such as corporate beneficiaries to match, or will this be staying at 30%?
At present, it's 30%. I haven't heard anything that's changing. We will like it to change, but it's really holding companies carrying on a business that's different, but investment entities still 30%. So there's a big difference where you get a dividend at 26%, and you're a company that's an investment at 30 cents in the dollar, you might have a top-up tax.
So
just keep that in mind. There is a gap.
So is that the way the government is trying to drag money out of the high net worths and the investment structures?
Yeah, I guess, they see the businesses as carrying on business. They want more business. They want to develop that, and they're reducing the tax rate. Mm-hmm. But, they're sort of keeping that higher rate, so you can't just put your money into, if a trust distributes to a company, it can't just sort of sit there and no tax is paid, sit in an investment company, which is a tactic, it's used.
And the last one we have, unless there's any more, employee versus contractor. Hasn't COVID given us the opportunity or advantage of helping with the definition, because contractors have accessed JobKeeper independently of the employer company, which is what Mark's saying. Is that right, Nick?
I love that question. I think it's clever. I don't think it's the answer, but hey, if I was in your situation and I had a contractor that wanted to suddenly contend that they were an employee, that would be one of the factors that I would hold up. That we're in a situation at the moment, as it stands, where there is no definition. The court adopts this totality test, and you've got to appreciate that these contractor employee cases come up in so many different forums. You might have one that's about tax, you might have one that's about super, you might have one about unfair dismissal. So it really depends on the agenda. So you might have a situation where someone's happy to be a contractor and be paid as a contractor, but then they're terminated and say, well, I want to claim entitlements. The court will look at the totality test in that context. So one factor is not really determinative. And you've got to appreciate that often contractors have signed contracts saying that they agree that they're a contractor and they have legal advice. Doesn't mean that that's going to result in a finding that they're a contractor. But I like your way of thinking. I'd be doing the same.
But Nick, also, I guess from a tax perspective, you know, it might be different from your perspective, from a HR perspective.
Absolutely.
So,
perfect example, Mariana, would be superannuation. So
yeah.
you've got a lot of contractors that are genuine contractors at law that are deemed employees for superannuation purposes.
They're usually individuals though, aren't they?
Usually
we're talking about.
Yeah.
I mean, you know, PAYG and super are one of the things that, you know, employers need to watch out for, but they brought in these personal service entity rules,
Yep.
which if the employer hasn't caught it, these rules would catch it to sort of say whether you should be paying PAYG withholding or super within your entity. So if you're a company contracting. But I think the danger here is always payroll tax, state payroll, because a contractor can be caught, even a company can be caught under the payroll. And one of the danger ones that we've sort of seen happening before COVID was the employment agency. And that was quite wide and sweeping, the definition. There's been a fair few cases now, but that's something to always watch out for, because if you come under employment agency, meaning I've employed someone to go and work for a client, right? So I may pay them, but they're working for the client. That could be an employment arrangement. And that means that that person can't get an exemption under the contractor rules. So that's why it's so important. So yes, so different definitions for different areas of the law. So I think it's a minefield for employers.
And then you layer on top workers' comp responsibilities and things like that. So it's clarity on those things is going to be important going forward, and we're going to see a lot of that, I suspect. So unless there's any other questions, because we've run over, we will bid everybody a good morning. If anybody would like to look at the panel and the poll, here it is. If you'd like to talk to anybody around each of these things and answer any other specific questions, please let us know. We may reconvene in April to see how things are starting to roll out in the back end of April, or maybe early May after Easter. And we'll see what the impact has been of all this uncertainty and where we're going from there. Thanks for your time.
Also, Todd, can I just say that I think it's always good to keep an eye out what happens to the end of March, because governments tend to sometimes bring out things suddenly, and whether they narrow the focus to certain industries, because, you know, even though we have the vaccination, some industries haven't really gone back to normal. So I just keep an eye out. Obviously, we'll be pushing out any information, and we might do a quick pop-up if something does come out which would be of interest.
Yep. I would like to thank Todd, Mariana, Nick for your time this morning, and that concludes our webinar. And thank you for everyone for joining. Thank you.
Thank you.